Very good afternoon to one and all. On behalf of IMT College of Law, I welcome you all to this today's workshop on intellectual property rights and IP management for startups. This workshop is organized by IIC Cell of IMT College of Law under the esteemed guidance of Professor Dr. Monica Rastogi ma'am. And today we have respected Mr. Ashok Karnani, Assistant Professor, R&B, Global University, as our guest. A teaching professional with 16 years experience in industry, he has an immense passion for shaping and worked various reputed institutions in the city ranging from senior secondary school, public school to post-graduation degree ranging from M.Com double, LLM double in various streams. Also, he is pursuing MSc. He has also helped on various educational streams and professional during extreme levels of career diversion and decision making. I welcome you, sir. Over to you.
Thank you, ma'am. Good afternoon, one and all present here. Myself, Ashok Karnani, and my topic is intellectual property rights and its management by corporate and startups. First of all, for this topic, we have to clear what is intellectual property right. Intellectual property right is a category of property that includes intangible creation of the human intellect. They usually give the creator an exclusive right over the use of his or her creation for a certain period. It means the right is only of that particular creator who creates that particular creation. The most well-known types are copyrights, patent, trademark, and trade secret. These all are the intellectual property rights. The modern concept of intellectual property right can be traced back to 20th century, though it was not until the late 20th century that intellectual property became compliance in the majority of the world legal system. With the rapid increase in the globalization and the opening up of the new avenue in India, the intellectual capital has become one of the key wealth drive in the present era. There are different country specific legislation as well international law and the treaties that govern of international intellectual property rights. Now, what is the need for intellectual property? It means there are certain reasons for that purpose we can say that we have to read intellectual property. An efficient and equitable intellectual property system can help all countries to realize intellectual property potential as a catalyst for economic development and social and cultural well-being. The intellectual property system helps to strike a balance between the interests of innovators and the public interest, providing an environment in which creativity and invention can flourish for the benefit of all. It means we can say that we want to balance between the creator and the society. For that, we have to read intellectual property rights. Now, what are the provisions? What are the systems to promote intellectual property? We can say that we have several compelling reasons that we have to promote these rights. First of all, the progress and well-being of humanity rests on its capacity to create and invent new work in the area of technology and culture. Second, the legal protection of new creation encourages the commitment of additional resources for further innovation. Next, the promotion and the protection of intellectual property for economic growth, create new jobs and industries, and enhance the quality and the enjoyment of life. It means these are the reasons that we can say that we have to need intellectual property right, or we can say that for this reason we are trying to create some right just like a intellectual property right. Now we have discussed these rights in some elaboration. First of all, trademark. The Trademark Act 99 provides inter alia for registration of trademark, filing of multi-class application, the renewal term of registration of a trademark as 10 years, as well as recognition of the concept of well-known mark, etc. The trademark symbol is a symbol to indicate that the preceding mark is a trademark. It means no doubt we can say that particular mark for a particular trade is specifically an unregistered trademark. It complements the registered trademark symbol just like that. We can say that if we want to register my trademark as R, which is reversed for the trademark registered with an appropriate government agency. Trademark means any word, symbol, logo, slogan, product packing, or design that identifies the goods or services from a particular source. It means with the help of this trademark, we can identify a particular product, particular goods, as per the definition provided under Section 2 of the Trademark Act. Trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others and may include shape of goods, their packing and combination of colors, etc. The definition of the trademark provided under the Trademark Act is wide enough to include non-conventional marks like color marks, sound marks, etc. Again, as per Section 2M, trademark include a device, brand, heading, label, ticket, name, signature, word, letter, numeral, shape of goods, packaging or combination of color or any combination thereof. Accordingly, any mark used by a corporate in the trademark or business in any form for distinguish itself from other can qualify as trademark. It means no doubt our trademark must be distinguished from the other product. It is a quite significant to note that the Indian judiciary has been proactive in the protection of trademark and it has extended the protection under the trademark law to domain names. It means no doubt our judiciary regularly try to protect trademark. It means some of people can misuse of these trademarks. Indian website, we have to given a website on with the help of this website we can easily find out the legal provision. Now, point to consider while adopting a trademark report. This one must do proper due diligence before adopting a trademark. It means no doubt let buyer be aware. We can say that before adopting any trademark, we have to alert about the procedure, about the mark. If there is any mark registered before given us that mark, that will be not legally approved. The trademark can be broadly classified into following categories like that: generic, descriptive, suggestive, arbitrary, invented, enforcement of trademark, point, etc. Now, what are the enforcement of trademark rights? Trademark can be protected under the statutory law, under the Trademark Act and common, under the remedy of passing off. If a person is using a similar mark for similar or related goods or services, or is using a well-known mark, the other person can file a suit against that person for violation of the intellectual property right, irrespective of the fact that the trademark is registered or not. It means if any person trying to use unfair trade practice by using of trademark, you can easily file a suit. Registration of a trademark is not a prerequisite in order to sustain a civil or criminal action against violation of trademarks. It means registration is not necessary. Before registration, you can file a suit against that person who is trying to misusing your particular trademark. The relief which a court may usually grant in a suit for infringement or passing off include permanent or interim injunction, damages or account of profits, delivery of infringing goods for destruction, and cost of legal proceedings. It is pertinent to note that infringement of trademark is also a cognizable offence, and a criminal proceeding can also be initiated against the infringer. It means no doubt using trademark on illegal manner is a cognizable offense according to CRPC. Now we are trying to discuss about patent. Patent in general parlance means a monopoly given to the inventor on his invention to commercial use and exploit that invention in the market to the exclusion of other for a certain period. As per section 2, clause 1, subclause A of the Patent Act 1970, invention include any new and useful art, process, method, or manner of manufacture, machine, apparatus, or other article, substance produced by manufacture, and include any new and useful improvement of any of them, and an alleged invention. The definition of the word invention in the Patent Act also include the new product as well as new process. It means we can say that in the term of patent, both are included, either new product or new process. If there is any such pattern is also exists, but we want to adopt a new process for that a particular process, that is also patent. Therefore, a patent can be applied for the product as well as process, which is new, involving inventive step and capable of industrial application, can be patented in it. Inventions which are not patentable, it is important to note that any invention which falls into the following category is not patentable. It means now we are going to discuss, point out that point that can't be patentable, just like a obvious, contrary to well-established natural law, contrary to law, morality, injurious to public health, a mere discovery of a scientific principle, the formulation of an abstract theory, a mere discovery of any new property or new use of for a non-substance or process, machine or apparatus. A substance obtained by a mere admixture resulting only in the aggregation of the property of the component thereof or the process for producing the substance, a mere arrangement or rearrangement or duplication of non-device, a method of agriculture or horticulture, and invention relating to atomic energy or invention which are known or used by any other person or us or sold to any person in India or outside India. These are the ground that can't be patentable. The application for the grant of patent can be made by either the inventor or by the assignee or the legal representative of the inventor. It means it is not necessary that the person who want to grant patent must file the application for patent on the behalf of that patentee. Also, his legal heir or assignee also can file the registration process. In India, the term of patent is for 20 years. The patent is renewed every from date of the patent. It means no doubt, first time we can obtain the permission for patent is 20. Now, our next intellectual property right is copyright. Copyright means a legal right of an author, artist, originator to commercially exploit his original work which has been expressed in a tangible form and prevent such work from being copied or reproduced without his or her consent under the Copyright Act 1957. The term work in which copyright subsists includes an artist's work comprising of painting, a sculpture, a drawing, including a diagram, map, chart, or plane, and engraving, a photograph, a work of architecture or artist, dramatic work, literacy work, include computer program, table, and computer database. Any musical work, sound recording, and the cinematography film, these all are the term of copyright. In the case of original literacy, dramatic, musical, and artistic work the duration of copyright is the lifetime of the author or artist and 60 years counted from the year following the death of author. And in the case of cinematograph, film, sound recording, publication, anonymous, and the work of government and work of international organization are protected for a period of 60 years. It means, as we earlier discussed in case of other trademark, the time duration is different from copyright. In order to keep pace with the global requirement of harmonization, the Copyright Act 1957 has brought the copyright law in India in line with the development in information technology industries, whether it is in the field satellite broadcasting or computer software or digital technology. Now, what are the process of registration of copyright? In India, the registration of copyright is not mandatory, as the registration is treated as mere recorded of a fact. The registration does not create or confirm any new right and is not a prerequisite for initiating action against infringement. The view has been upheld by the Indian court in a certain judgment, despite the fact that the registration of copyright is not mandatory in India and is protectable through the International Copyright Order 1999. It is advisable to register the copyright as the copyright registration certificate is accepted as a proof of ownership. It means it is not mandatory, but for our protection, for our betterment, we have to obtain the registration certificate of copyright in court and by police authority and acted upon smoothly by them so that we can easily protect our copyright with the help of certificate. Enforcement of copyright in India, any person who used to original work of the other person without obtaining license from the owner infringes the copyright of the owner. The law of copyright in India not only provide for civil remedy in the form of permanent injunction, damages, or account of profit, delivery of infringing material for destruction and cost of legal proceedings, etc., but also make instances of infringement of copyright a cognizable offense. It means that type of offense also come under the Criminal Procedure Code, and that is also cognizable and punishable with the imprisonment for a term which shall not be less than 6 months, but which may extend to 3 years. It means in the case of infringement of any copyright, the time period of the infringement 6 months to 3 years, and with the fine which shall not be less than 50,000 but may extend 2 lakh rupees. It means no doubt imprisonment as well as fine. Now our next point is industrial design. As per the definition given under the section 2D of the Design Act 2000, design means only the feature of shape, configuration, pattern, or ornament applied to any article by industrial process or means, whether manual, mechanical, or chemical separate or combined, which in the finished article appeal to and are judged solely by the eye. It means no doubt this is a type of shaping any design for a particular item. However, design does not include any mode or principle of construction or anything which is in substance a mere mechanical device and does not include any trademark as defined under the Trademark Act or any artist's work as defined under the Copyright Act 1957. The total period of validity of registration of an industrial design under the Indian Design Act 2000 is 15 years. It means you have to very clarify that on the basis of tenure of registration period, each intellectual property rights is different. Some is valid from 10 years, some 20, 60, and 50. Now, feature of shape, configuration, pattern, ornament, or composition of lines or colors apply to any article whether in two-dimensional or three-dimensional or in both forms, can be registered under the Indian Design Act 2000. However, functionality aspect of a design are not protected under the Indian Design Act, as the same are subject matter of patent. Design of an article is not registrable in India if it is not new or original, had been disclosed to the public anywhere in India or in any other country by publication in tangible form, by use in any other way prior to the filing date or priority date of the application, is not significantly distinguishable from non-design or the combination of non-design or comprises or contain scandalous or obscene matter. Now, enforcement of design right in India. The Indian Design Act only provides for civil remedy beside injunction on monetary compensation is recoverable by the proprietor of the design either as contract debt or damages. It means no doubt if any person want to misuse of design of other, then he can be remedied with the help of contractual value, or we can say amount of damages. And action for infringement of design can only be initiated after the registration of design. It means in that case, the design must be registered. If you want to file a suit for a recovery of damages or compensation, your design must be registered under the Design Registration Act 2000. However, an action for passing off is maintainable in case of unregistered design. Last, our geographical indication. A geographical indication is a name or sign used on product which corresponds to a specific geographical location or origin. The use of a geographical indication as an indication of the product source act as a certification that the product possesses certain qualities, is made according to traditional method, or enjoy a good reputation due to its geographical origin. And appellation of origin is a special kind of geographical indication used on products that have a specific quality exclusively or essentially due to the geographical environment in which the product are produced. Now, what are the generic of geographical indication? If the name of a place is used to designate a particular type of product rather than to indicate its place of origin, the term no longer functions as a geographical indication. For example, Dijon mustard, a kind of mustard that originated in French town of Dijon, has over time come to denote mustard of that kind made in many places. Hence, Dijon mustard is now a generic, now a generic indication and refer to a type of product rather than a place. Last but not least, trade secret. Trade secrets include any confidential business information which provide an enterprises are competitive as for others. Trade secret encompasses manufacturing or industrial secret and commercial secret, like that formula, practice, process, design, instrument, pattern, commercial method, or combination of information which is not generally known or reasonably ascertainable by others. The unauthorized use of such information by person other than the holder is regarded as an unfair practice and a violation of the trade secret. There are no specific statutes under the Indian law for the protection of trade secret, and the same are protectable under the common law right. Trade secret, just like we can say that Coca-Cola, which is locked in a vault, is an example of a trade secret, that is a formula or a recipe. Since it has not been patented, it has never been revealed, The New York Times bestseller list is an example of the process trade secret. While the list does factor in book sales by compliant chain and the independent store sales, edge, well-edged wholesaler data, the list is not merely sells number of books. Strategy for the protection and the exploitation of intellectual property right for the startup. Now, we want to discuss what type of strategy we can follow to protect our right. Number first, make intellectual property protection a priority. Register intellectual property rights, due diligence of intellectual property rights, implement clear and effective policies and strategy for protection of our intellectual property rights, agreement related to intellectual property right startup. Valuation can be made on the basis of intellectual property right. New companies don't really have monster product, stock, or workforce to begin with. Subsequently, a large portion of the estimation of startup, for the most part, get from their intellectual property right. It has been assessed that on the normal, over 80% of the estimation of a new business depend on their IP, यानी कि intellectual property right full. Thank you. Thank you, ma'am, for giving me this opportunity.
Thank you so much, sir. In case anybody has a question, please you can raise your hand. Okay, I don't think anybody has a question. So as we have come to the end of this session, I thank you so much, sir. We at Iic College of Law are indeed blessed to have you with us today. Our students have learned a lot from you, sir, today. Thank you once again. I thank all the students and participating faculty members for their patient listening. Thank you all.
Thank you so much, ma'am.
Thank you.